From my review of the financial records, they're making roughly 100 to 140 million a year. They can afford to put him on a private plane, have him masked up and bring him here, and let the jury look at him, look at his mannerisms, test his credibility in full.
One more, it's about 15 minutes.
All right, that's fine.
Excuse me, 25 minutes, I'm advised.
This one here?
No.
Okay, something different. Okay.
We call Blaine Jones. All right, we call Blaine Jones by video.
Yes.
Yes.
So, Mr. Jones, did you drink marijuana?
I did.
Okay, could you take a look at Exhibit 26, please, and tell me if you recognize that document?
I don't recognize the document specifically, but I recognize what it's, thank you, describing.
Okay. Well, this appears to be a narrative that was put on a GoFundMe page. Okay? Did you put a narrative on a GoFundMe page?
I did.
Okay. And does this appear to be the narrative that you put on the GoFundMe page?
Appears to be. I can't recall specifically what I said, and if this is 100% accurate, but...
Okay. Approximately when did you put the narrative on the GoFundMe page?
Looks like it was 25th of October, 2020. Has that date on the document there? Sounds about right.
Where are you looking? On the page?
It says 501.
Okay. You're looking at Spanish on the bottom?
Yes.
Where it says Fecha de Creation?
Correct.
You speak Spanish, right?
Not fluent, but yes.
You know Fecha means date? Right.
Yep.
So you're assuming that the date of creation of this is October 25th?
Yes.
Is that consistent with your memory that you did create this on October 25th?
Sounds about right.
Okay, back to the first page. Could you read the first full paragraph that starts with "My name is Blaine Jones"?
My name is Blaine Jones. The pain, confusion, and fear I have learned about acute liver failure and hepatitis over the last few weeks invokes the old phrase, I wouldn't wish it on my worst enemy.
Okay, and this says the last few weeks, and we've had the date of October 25th on the page. Does this refresh your recollection as to when you had this liver injury?
It was October of that year, yeah?
October 2020, correct?
Yes.
Okay, now there's some reference made in here to a hunting trip?
Correct.
And where were you going hunting?
Utah.
Can you get a little more specific?
Just outside of Carbon.
What were you hunting for?
Elk.
You got tags?
I did.
Okay, and you were accompanied by someone?
I went up there alone, but I knew someone that lived in the area and I met up with him.
One of your friends, I assume.
An acquaintance, I had met him.
What was his name?
I don't specifically recall his name, to be honest with you right now. I had only met him one time prior to that, and I haven't spoken to him since.
Okay. If he had a tag too?
He did not know. He knew the area, and he offered to show me around.
He was more of a guide person?
No, he wasn't a guy.
Oh.
Acquaintance.
Okay. All right, so does this... Anyway, you drove to Utah from Nevada?
Yes.
Do you remember if you left on a Thursday, Friday, Saturday?
think I left on like a Thursday, something like that, maybe a Wednesday.
Okay, if you want to take a look at the second page, I think maybe if you give a little context to it. 1, 2, 3, 4 down. Could you read that paragraph?
Which paragraph again, sir?
Where it says after the morning hike, and then we'll try to put this into some kind of context.
After the morning hike, I thought I had full-blown food poisoning.
Now, was this the first full day in Utah?
So that day, I had arrived the day prior
Okay.
and set up camp and, different things.
Was that the day you went to KFC?
No, it was yes, I believe so.
So on the day you arrived, you went to KFC, right?
I believe so, yes.
And you said, quote, later that afternoon I began to feel sick, unquote.
Yes.
Right? Okay, so you actually started feeling sick the day that you got there.
Yes, I believe so.
Did you bring real water with you?
I did.
How much, if you know?
I believe I brought a 5-gallon bottle.
So you were drinking it during the course of being up there?
Correct.
Did you bring anything else other than real water to drink?
I might have had some other Gatorade or some other type of drink, probably.
Okay. Okay, so basically you started getting sick that afternoon, right?
Correct.
And you said, quote, nausea came over me that night, unquote. Do you remember that?
Yes.
And in the morning, you had what you thought was, quote, food poisoning, unquote, right?
That's what it initially felt like, yes.
Okay. And having had food poisoning, you're throwing up a lot, and you're feeling nauseous and weak, right? Okay, so then it says that afternoon I went to sleep, and this was Saturday, right?
That's what it says there, yeah, sounds all right.
So this was the Saturday after the Friday that you got there.
Correct. I believe so.
It says Sunday you slept all day, only to wake up at midnight feeling decimated after having thrown up and dehydrated.
Yeah, that's what it says.
You need to take that? And,
No, it's fine.
okay, and is that in fact what happened?
Yeah, as best as I can remember.
Okay. Had you ever felt this way before?
I can recall having, food poisoning where I felt similar to that. However, Sunday, it kind of progressively got worse. So it felt at that point in time like a very bad case of food poisoning. Very severe case, I guess you could say, of food poisoning.
Okay, so it says you slept all day. Was that on site at the hunting area?
Yeah, I was in a tent.
You set up a tent?
Correct.
And was that just for you, or was the other guy sleeping up there too?
I had my tent by myself, and he had his own tent.
Okay. So it says, quote, I decided I needed to go to the hospital for attention, right?
Yep.
And did you go to the hospital for attention?
I did.
And what hospital would that be?
The local hospital there in around Carbon. I don't remember the name specifically off the top of my head.
Carbon spelled C-A-R-B-O-N?
Yes.
Okay, but whatever the local hospital was in Carbon you went to?
Correct.
Okay, it says you went into the ER, they gave you some tests, and then fluids, and then they let you out, right?
Yep.
How long do you think you were in the ER at that point in time?
Maybe an hour or two.
Okay. So you drive back to camp and you say Monday you slept all day. Is that right?
That's what it says, yeah. Sounds right.
So you actually slept all day Sunday and all day Monday.
Besides the trip to the hospital, yeah.
Okay.
For the most part, I think.
It says you had no energy. I had no energy to get up, barely enough to choke down some water. Did I read that right?
That's what it says, yeah.
And so the water would be the real water?
Most likely, yes.
Okay. So during the time period you were sick, you were still drinking the real water?
Correct.
Okay. Moving on. I dumped myself into my truck and he drove down the mountain to the pharmacy. Would that be your friend?
Yeah.
Okay, and so what day would this have been?
I don't recall specifically if it was Monday or Tuesday.
Okay, if you take a look back up the paragraph, after it says Monday you slept all day, it says, quote, the next morning I felt the necessity to get up.
Okay, yeah, so then I guess it would have been Tuesday.
Okay, so on Tuesday he drove you down the mountain to the pharmacy, correct?
Yes,
Okay, so you filled the prescription, you went to your friend's house to rest, right?
correct.
And you say, quote, what I would soon realize was I had a few levels to fall down before I hit the bottom of this nightmare.
Yep.
Right? And the nightmare would be the illness you're suffering, correct?
Correct.
Okay. So the next paragraph says you got off the couch. Is that the couch at his house?
I believe so.
And again, we think this is Tuesday, right?
Sounds about right.
Okay. So you described going to the bathroom and you think you went multiple times and he says you went once, right?
Yes.
So you were delusional at this time?
Yes.
So you went outside and it sounds like you're kind of stumbling down the street. Is that what's going on?
I was out in front of his house.
Okay. So your mother called an ambulance?
Yes, I was trying to reach somebody that I knew, and she was the only one that answered the phone at the time.
Okay, so this would have been Tuesday night?
Afternoon,
Tuesday afternoon, okay.
maybe midday, I'm not sure.
And this house is in Carbon, right?
Yep.
All right. So the ambulance arrived and they put you in the back of the ambulance and they take you to the hospital, I guess, right?
Yeah.
And skipping over a paragraph, it says, quote, next time I remember being reeled down the hall into a room with a doctor. Over the next few hours, I was given IV fluids. Next, the doctor told me my liver was shutting down and the next few days would be very painful. Did I read that right?
Looks like it.
So this would have been on Tuesday?
Yes.
So Tuesday, a doctor told you that your liver was shutting down, correct?
I believe that was what the doctor said, yes, if I remember correctly. Again, I was pretty out of it, but as far as I can remember, yes.
Okay. And do you know what ALT and AST liver tests are?
I'm familiar, somewhat, very elementary understanding of it.
Okay, do you know if they ran those on you at this time?
I don't recall or not, no.
Was there some other member of the family communicating with the hospital about your condition other than, well, was there other than you?
I believe they got a hold of somebody. I don't know specifically who they were speaking to.
Okay, and the next sentence, it says they notified your father, right?
Yeah,
Okay, and that would be Brent Jones, right?
correct.
Okay, and so he actually talked to you and said, I'm going to come get you?
I don't remember if I talked to him or if the doctor relayed the message. I just remember somehow knowing that he was coming to pick me up.
Okay, well, it says, quote, he gave me two options. One, stay in the hospital, or two, go to the hotel, right?
Yeah, I was referring to the doctor.
Oh, the doctor gave you two options. Okay. So you went to the hotel.
Yes.
And the reason you went to the hotel is because you were worried about the medical bills since you had no insurance?
Yep.
Would you have otherwise stayed in the hospital?
The way the doctor put it and giving me that option, he was basically saying it was, up to me what to do. At that point in time, like I said, I didn't have health insurance, so I made the decision to go to the hotel.
Okay, and you walked from the hospital to the hotel?
Yeah, it was just down the street, maybe 100 yards or so, 200 yards.
Okay, and you say, quote, I left the hospital on the hardest, less than a block walk I've ever experienced, unquote. Did I read that right?
Yep.
Okay, you were stumbling and fell on the ground over 15 times?
Sounds about right.
So 15 times in 100 yards?
Yep.
Okay. You were in good shape, I take it.
I was not.
Okay. So, flip over to the next page. Had you already checked into that hotel, or did you have to check in the hotel?
I honestly don't remember or recall how I got the key or the reservation for the room.
You were out of it.
Very much so.
Okay. But you say here you flopped in the hotel bed, right?
Yep.
Okay. And then your wife convinces the hotel people to feed you some Advil, right?
Yeah, they left some food and Advil, out from my room.
Okay. And then your dad comes up, right?
Mm-hmm.
Yes?
Yes.
And in the next paragraph, it says, quote, "The doctor warned me you were going to feel horrible for a few days," unquote. Was that before you left the hospital?
When he gave me that warning,
Yeah.
it was when I was at the hospital, yes.
So you went back to the hospital after your father came?
No.
Okay.
Not at that point in time.
So while you were at the hospital, he told you this?
Yes.
Okay. And now it says this was Wednesday now, right? We're on Wednesday?
Yes, that's what it says. Looks like it.
Okay. And so your dad drives you back to Vegas, I assume, right?
Yep.
Okay. Okay, so they set you up kind of a little room here at your house, I take it, right?
Yep.
And then you got a case of the hiccups?
Yeah, I remember it started on the drive home, and
It says you're forcing fluids down. Is that during the drive?
where
During the next 2.5 days, my time was filled with hiccups, forcing fluids down, and every time I trip to the bathroom for the fluids to come back up.
yeah, so that was when I was at the house, and like I said, in the room that I got set up in the bedroom.
In the fluids, you were still drinking the real water?
Probably that's would have been the water we had at the house. I don't remember. I can't. It's hard to convey the difficulty of being aware of what's going on
Okay.
at that point in time.
But you started getting worse at home. That's what it says.
Yeah, over the next couple of days, and as the doctor told me at the hospital that the next few days were going to be very hard, and I definitely did continue to get worse.
Okay, you got worse than you were when you were in the hospital and when you were stumbling 15 times, walking 100 yards to the hotel?
Yeah.
You were worse than that even?
Yep.
Okay. All right.
I was throwing up blood and not able to hold anything down,
And the throwing up blood, that's the reference to the red-brown mix of fluid exiting my mouth?
Yep.
It says your grandmother, had come from 5 hours away to aid in my care.
Yeah, she came to help.
Where does she live at?
She lives in California.
Just after midnight on Friday, her voice uttered what I needed, hospital.
Yep.
So she told you to go back to the hospital?
Yes.
And so Friday, we're a week after, well, this is the Friday after you went to Utah on the Friday.
Correct.
So this was 8 days in a row you've been sick?
Friday to Friday would be 7 days.
Okay.
8 days.
All right.
Something like that, yeah.
Okay. And then to the car and you go your third trip to the hospital.
Yep.
So that's 2 trips to the Utah hospital, third trip to a hospital here in Vegas, I assume, right?
Correct.
Okay. And what hospital is that?
I don't recall the name of it off the top of my head. It's the one here up in Oh, it's north of the 215 over off of Buffalo, somewhere in that area over there.
North of 215 by Buffalo. Okay.
Yeah, I can't remember. Spring Mountain maybe is the name of it. I can't remember
Okay.
what specifically.
Have you been to the hospital before?
To that hospital?
Yeah.
No, I haven't been to that hospital.
Okay. So anyway, they checked you into the hospital, right?
Yep.
And you say, I was diagnosed as critical and rushed into the ICU. That would be the intensive care unit? Yep. So they checked you into intensive care? Yep. And we're in the middle of COVID right now, aren't we? October?
Maybe it was ramping down, but I mean, it depends on what your definition of the middle of COVID is, I guess.
They had COVID restrictions at the hospital still?
Yeah, I mean, still have COVID restrictions in hospitals right now.
Okay. So this weekend, I stayed under constant supervision, blood tests every 4 hours, and something continuously being injected into one of my 2 IV connections. Did I read that right?
Looks like it, yes.
So that weekend would be the Saturday and Sunday after you checked into the Vegas hospital, correct?
I believe so, yeah.
Okay, next sentence says, quote, the doctors don't know why I got sick, unquote.
Yep,
Did the doctors tell you they didn't know why you got sick?
they did.
And I assume they asked you if you did alcohol, right?
Yeah, they had a number of different questions,
Okay, and do you use alcohol?
and occasionally.
Okay, so they ruled out alcohol, right? Or you ruled out alcohol.
I mean, I from my understanding of, cirrhosis and liver failure, I'm not drinking enough in my life to get to that point.
Okay.
I'm not a medical expert, obviously, but
You're an occasional drinker?
yeah,
Like 1 or 2 drinks a week, maybe?
at the most.
Okay, and it says, what they didn't know was if I had gotten worse, the only option was a liver transplant, unquote. Did I read that right?
Yes.
And did they discuss a liver transplant with you?
Yeah, a specialist came in and he said that there was a short amount of time where he was debating whether or not to send me to California for a liver transplant.
Did they tell you what hospital in California they were considering?
No, I don't recall
Okay,
specifically.
and remember if it was perhaps Loma Linda, USC, UCLA?
I don't remember.
Okay, what was the specialist name, do you remember?
I don't.
And you said he came in, he was not at the hospital, he came from another hospital?
The way he made it sound is he kind of circulated around hospitals because his specialty was something in regards to liver or something,
Okay. And it says, quote, my tests for liver failure were teetering at this point of no return, unquote. Did I read that right?
Yep.
And those would be ALT, AST tests?
They weren't reviewing tests with me at that point in time specifically. I just recall the conversation with that doctor. He basically, and this was shortly after I began to, not get worse.
Now it says, my tests for liver failure were teetering at this point of no return. Do you remember they were talking about your ALT or AST being in the thousands? Does that ring any bells?
I don't recall specifically what tests. I mean, other than generically referring to tests at that point in time. I mean, I'm still in the ICU and very, don't have all my faculties, I guess would be the way to put it.
Okay, the next paragraph says, by Monday, I was relocated to the general level of the hospital, stable enough to be transferred, unquote. Did I read that right?
Yep.
So that means on Monday, you're moved from ICU to general section hospital?
Correct.
So you've been in the hospital, you checked in Friday night, right?
Yeah. I think
So
so.
you've been there Saturday, Sunday, and on Monday, they moved you out of ICU.
I believe that sounds all right.
Okay, and would I be correct that they did not let you bring real water into the hospital?
I don't recall bringing anything other than myself in the hospital.
Okay, so the only liquid you drank at the hospital was hospital water.
I wasn't able to drink any liquid at the hospital for a good amount of time.
You didn't drink any liquids?
When I was in the ICU, I wasn't able to really drink or eat much of anything. And then I think just before they transferred me out, I had some like liquid food. I was able to keep that down. And then when I was in the general sort of recovery area, was when I was actually able to, drink some water and get some food from the cafeteria or they would deliver food to your room.
Okay, you wouldn't drink the water, that was hospital water, not real water.
It was the water they provided, yes.
Okay. All right, and it says, I skipped something, it says that you were having blood tests every 4 hours during the weekend. See that in the top there?
Yeah, there was a nurse that would come in when I was in the ICU every 4 hours to take a sample and run tests.
And you know if those were the liver tests that we're talking about?
I don't know what they were testing.
Okay, the next paragraph says, Tuesday morning, you want to be discharged. So you went home Tuesday morning?
Late morning, midday, somewhere around there, yeah.
It took me a week and a half of hell to achieve my regime of rest at home. Unquote. Did I read that right?
Regimen.
Regimen, okay. So Tuesday morning you went home, right?
Yep.
And how long did you stay at home before you were able to go back to work?
I want to say it was about a week and a half.
Okay. So since we got about a week and a half to Tuesday morning, you were pretty much put out of commission for 3 weeks. Is that about right?
Yeah, and I mean, I was still extremely weak and out of it even at that point in time, after that point in time.
Okay, and it says, in the next sentence it says that debilitation of liver failure, I have been to hell and back. Did I read that right?
Yeah, it was a very terrible experience.
Okay. You would go through this again if I gave you $10 million, would you?
No.
Your Honor, it's just as Exhibit 7, Plaintiffs Exhibit 77, we move to admit that's the GoFundMe letter that is discussed in Mr. Jones' deposition.
No objection.
No objection.
No objection.
All right, shall be.
Your Honor, I missed Mr. Savaggio, I missed Exhibit 375, that's the comment.
No objection.
No objection. Did you say 375?
Plaintiffs 375.
Shall be admitted. All right, ladies and gentlemen, we're done for the day and it's still not 5 o'clock. Okay, it's been good so far. And tomorrow we're going to start at 10:30. It's my understanding we have one of the members of the jury that has a doctor's appointment in the morning. Is that correct, sir?
That's correct.
Yeah, that's what I thought. Yeah. Anyway, you're admonished not to converse amongst yourselves or with anyone else on any subject connected with this trial, or to read, watch, or listen to any report of our commentary on the trial by any persons connected with this case, or by any medium of information, including without limitations, newspaper, television, radio. Remember the social media prohibition, and you're not to form or express any opinion on any subject connected with this trial until the cause is finally submitted to you. And so tomorrow morning, 10:30, we'll be ready to go.
Yes, Your Honor. All rise to the report to the jury.
Jury's clear. Please
Okay,
be seated.
thank you, sir. And so, counsel, what do you think tomorrow, 9:15?
Sure, we're not a dog in this fight.
Okay, well, you can come in anytime before 10:30 if you don't have a dog.
We do not, thank you.
Oh, that's fine. All right, so it's 9:15 for everyone else.
9:15 tomorrow?
Yes. Because we have the motion, right?
Yes, Your Honor.
9:15.
Court 16 is now in session. I'll preside. Please be seated.
We're on record now.
And thank you, ma'am, and let's go ahead and set forth our appearances.
Milwaukee, I'm Pepperman and Teddy Parker. Good morning, Your Honor, Rob Robbins from Milwaukee.
Morning, Your Honor. Scott Rasmussen on behalf of the Hanna Instruments.
Odou, he's not here?
Not for this.
Okay. Anyway, we have defendant Milwaukee Instruments emergency motion pursuant to Rule 43 for testimony contemporaneous transmission. Is that correct?
That's correct.
Okay. You have the floor, sir.
Thank you, Your Honor. I don't have too much to add to the brief. I think it was briefed pretty well, frankly.
Tell me about the document.
the document in question is on, and I think I think might have opened the door on it anyways, we'll see, but when the video deposition of both Bush and particularly Jason Brown was played, they put up the video where Mike Bush asked him, you know, what do we have to do with these older meters, or how to calibrate the meter, or something like to that effect. And he refers him to a link, okay, and the link is for the kit. But the kit was discontinued.
No, I understand that, I understand the facts.
Okay, well, the dates is what I'm trying to get
Yeah.
at. The date of that is 2019, the kit was discontinued in end of 2017, I believe. So 2 minutes, that was at 11:53. At 11:55, he realizes that kit is no longer available, and he sends a subsequent email with instructions on how to calibrate the probe using vinegar. So that's what I need. That's really, I mean, there might be some other issues, but that's the primary issue that we'll be having Mr. Brown testify to authenticate that document. But as I said,
Was the document produced during discovery?
yes, that was the subject of the motion to strike that was pending for 6 months.
Well, they say it wasn't. Pursuant to 16.1 produced, wasn't produced at any time during the course and scope of the
Right,
litigation, wasn't disclosed pursuant to the special master's order, et cetera, et cetera.
Okay, it was produced, Your Honor, and we argued that extensively, not only by briefing, but probably a 2.5-hour hearing on that issue. So, in your court, and Your Honor ruled on that issue already.
What did I roll?
You denied their motion to strike entirely.
Okay, well, that
Documents.
dealt with his testimony. I'm talking about the document. That's a different issue.
We weren't, I mean, we can go back and pull that whole hearing up, maybe we should, but,
I mean, my point is this, and it's really simple. There's a difference between deposition testimony and striking the witness's testimony and the standards that would be applicable versus whether or not a witness can rely upon a document that wasn't produced before the period of discovery.
it was produced before the end of discovery. So, and that was briefed and argued. And it wasn't about his deposition testimony, it was specifically about that document that I just described. That's what the whole hearing was. With regard to our
So what
motion,
motion was that? What motion and when was that?
plaintiff's motion to strike, answer, and.
See, that's a different, I'm not
No,
straight, no,
let me
but
just-
no. Just because I didn't strike the answer doesn't mean the document can be used.
It wasn't just motion to strike the answer.
Well, that's how I looked at it. I mean, it appeared to be the thrust of the motion. And if I didn't pick up on the nuances, I apologize. There were a lot of emotions involved. I didn't strike the answer. That's the lens I was looking at it through. As far as the use of the document, the fact that I didn't strike the answer doesn't mean the document can be used. Those are different issues, right? I mean, and there's a big difference there. Striking the answer and permitting you to defend your case versus whether or not you can utilize that document at the time of trial. Totally different issues, different analysis, et cetera, et cetera.
And I appreciate that, Your Honor. But if one were to go back and look at the tape of that hearing, we talked about almost exclusively, not the answer. We
Those
talked
are all
about the document.
interlocutory, right?
I'm sorry, say that
They're
again.
interlocutory, motions in limine and all those things. And my point is this, and I just want to be really clear. You said something that I agree with in a general sense. And of course, there's exceptions. But the public policy, and I do feel it's important to try cases on the merits, right? And so that stuck with me. And I remember you said that.
I did say that.
And that's why they strike the answer, right? But whether you can utilize the document, that's a different issue.
That was all part of the same motion.
I understand,
Yeah,
but
it was
now we got something different. Maybe I apologize, maybe I missed it, right? As far as striking the document or utilizing the document, striking the answer, whether he can participate at the time of trial. Those are all different issues. I mean, I don't mind saying it, I see that totally different, because I wasn't striking the answer.
And I'm sure Your Honor can appreciate, and that's already articulated, there were a lot of motions.
Right.
But I'm representing the court that we specifically argued about that document, about discovery
Okay.
dates, about how how they stored those documents in boxes, everything was argued on that, Your Honor.
And here's my next question. Did he rely upon it at the time of his deposition?
We didn't know about it at the time of the deposition,
Okay.
which was well before the discovery cut off, Your Honor.
All right. I understand, Mr. Robbins. Anything else, sir?
The substance of the motion that followed, prepared to argue for this morning was NRCP 43 and Supreme Court rule regarding when it's appropriate to allow witnesses to testify by video. And there's a strong favor. And, I mean, obviously, we would much prefer, I think everybody would prefer to have witnesses in person. The La Barbera versus Wynn Las Vegas case up to the same point. And we briefed the points in there. Counsel, the plaintiff's counsel has made a couple of arguments against it. In La Barbera, it was a gentleman living in Italy. Apparently there was a warrant in Las Vegas for his arrest, didn't want to come out here to testify. And the court said, no, you have to, and then he was referred, the court reversed that ruling. Here we don't, it's not the same issue. As we briefed pretty extensively and provided documentation pretty extensively, Mr. Brown has a severely compromised.
Oh, no, I don't doubt his health status.
And I just want to make sure the court is aware of a couple of things, that he is on
Yes,
anti-rejection.
yeah, he had kidney issues, severe. I get that.
And he's currently dealing with a potential rejection issue, so he's on a stronger anti-rejection medicine now that they give to him every 2 weeks. He doesn't know what day they give it to him. They just give him 24-hour notice and he has to show up, cannot reschedule it, cannot miss it. And that date is going to be next week. He currently is dealing with shingles due to the compromised immune system. Painful to wear clothes, even right now. So that's a new development as well that just popped up. And I won't get into where the shingles are affecting him, but it's not in places you would ever want.
Yeah, well, I'm not doubting his
Okay, thank you.
medical condition and so on and so on.
Well,
I have no reason.
if the issue this morning, Your Honor, is about whether there's good cause, I think there's more than enough good cause to allow him to testify by from a remote location by video. A majority of the witnesses in the case have testified through video depositions, so the jury seems to be able to weigh their credibility on those videos. This one, he would actually be live just by remote location, and it would actually be allowed to ask him questions, so I don't think there's too much prejudice there. Unlike the Barbera case, we're not dealing with whether he's in fear of being incarcerated, he's in fear of losing his life, and it's a legitimate fear. There's another argument is that we never intended to produce Jason Brown. He's on the witness list, so there's no surprise. And again, it says, it's the cost and we should bear the cost. This isn't about the cost. This is about, no matter how we fly him out here, subjecting him to situations, especially with COVID on the rise again, that almost took his life nearly a year ago. And we don't think it's fair to make the man risk his life to come out to answer a few questions. And that's all I have here.
Thank you, sir.
Maybe before I go through, just make sure that I put on the record.
Oh, go ahead.
Your Honor, just for the record, Scott Rasmussen, and instruments are joining the motion filed by Mr. Robbins. Also, the particular document is discussed. We plan on trying to do that particular one. Documented in our case, so I don't want to have this ruling that may go against Mr. Robbins with regard to this affect my ability, since there's no motion pending against my client with regard to that same thing. And it was disclosed and produced by Mr. Robbins during the course of discovery, hence it should be something that Hanna Instruments should be able to use. That's all I have. Thank you.
Thank you, sir. Mr. Berman.
Your Honor, that's, if I could, Your Honor, I'd like to address the comments made by Mr. Robbins first, and then get into the heart of our opposition. Mr. Robbins said a few moments ago that he'd already decided to bring Mr. Brown here because he was listed as a possible witness on his, I'm assuming his pretrial memo. If that's the case, why wait until after the court indicated that he couldn't use the document without foundation for his opening? The reason why this has become an issue is because of that conversation at the bench. If he actually intended to use Mr. Brown, he should have filed this motion long before we started trial. Because actually the motions, the rule 43 says, that you should do it at least 5 days prior to. So from a timing standpoint alone, he should have filed this motion to bring Jason Brown here live prior to trial start, which he didn't do. That's number one in Rule 43. The other comment he made that I would take exception to, Your Honor, he said that Jason Brown did not know about this particular email at the time of his deposition. His deposition was taken February 2nd, 2023, Your Honor. This document hails back to 2019. How does he not know about this document? It should have been produced as a part of their initial 16.1 on October 15, 2021, more than 2 years after the email was created, and then 2 years before his deposition was taken. And during his deposition, Your Honor, on February 2nd, 2023, he said he gave all of the documents, all of his emails to Carl Savaggio. Now, I want to bring this up because it's on two levels, it's important. Number one, if Mr. Jason Brown was telling the truth, then that document should have already been in our possession. Number two, given what Mr. Rasmussen just said, if that document was in fact genuine and they had it in his possession, Carl Savaggio, who's an employee, a CEO and vice president of Hanna, should have produced it because Mr. Brown said during his deposition that he gave all his emails to Carl Savaggio. So I appreciate Mr. Rasmussen getting in on this subject and joining the arguments of Mr. Robbins, but it cuts both parties here. Because Mr. Savaggio is an employee of each. And Mr. Brown indicated under oath that he provided all of his emails to Mr. Savaggio, which I said earlier on that Mr. Savaggio, working as a president for Milwaukee, Mr. Robbins' client, a CEO and vice president, or a vice president for Hanna, who was given all of the emails, and he failed to produce it. So that document was not available for Mr. Brown's deposition testimony when he swore under oath that he'd given all the emails to Mr. Savaggio. We didn't have it when Mr. Savaggio's deposition was taken, and we didn't have it for the other party to the email, Mr. Bush. So that document was so late. And Your Honor, you're ahead of me, but I'm getting there.
Okay.
The motion, and I'll jump to it right now, just so we can have it front and center, Your Honor. The motion to strike was to strike their answer. That motion didn't say, motion to strike exhibit 4592, email dated March 2019. That's not the title of that motion.
Well, the title was, quote, motion to strike defendant Milwaukee Instruments answer for violating the special master's order and failing to produce documents pursuant to 16.1.
Absolutely. And this was just one of many documents, and in fact, because the document came out so late, Your Honor, we had to do 2 or 3 supplements, given a chronology of the continuing violations of the rules. I'm gonna allow the court to pull that out so you can see.
I have it right here.
So, Your Honor, when we filed the motion to strike, and I understand what Mr. Robbins is doing, and I appreciate his enthusiasm behind this motion and his attempt to have his client come in to speak about a document that he would not otherwise be able to get in. But his client caused this problem. And Mr. Rasmussen's client caused this problem. So let's talk about the motion to strike. The motion to strike was on several bases, Your Honor. Number one, it was the insurance issues between SID International, SID USA, Hanna, and Milwaukee, which again was a part of the special master order. The other reason was, and what prompted part of the reason we had to supplement it, we asked from October of 2022 for a deposition of Mr. Brown. And we didn't get that deposition until February of 2023. In between time, we were trying to get answers to our written discovery, which was served in June 17, 2022, which wasn't responded to until months after, actually in January, after the special master order of December 15, 2022.
I mean, I'll take it to another level. I mean, I'm looking here at the conclusion. And the conclusion, the thrust and focus of the conclusion is essentially this. And it says, no customer complaints, no internal emails, no policies and procedures, no warnings or design materials, no insurance policy information from the parent SID, no excess policies, no insurance policies were produced. And so it's going right there. And so the thrust and focus was to strike the answer. And as far as striking the answer, I always have to look to under Johnny Ribeiro, and I wasn't asked to look at lesser sanctions, right?
I didn't ask for lesser sanctions.
Yeah.
I asked for the answer to be struck, Your Honor.
But my point is this, and it's real simple. If the documents aren't produced during discovery, or more importantly, weren't produced for the purposes of a deposition, and the deponent is going to rely upon those documents, you don't get a second bite of the apple.
Let me make it real clear for the record. Mr. Robbins, and I've known him a long time, and I believe he's a good lawyer and a friend of mine.
And I just want to say this about every lawyer, how am I saying this? Every lawyer in this room, this courtroom has goodwill.
And I'd say the same thing about Scott. I've known Scott for
every lawyer in this courtroom has goodwill. That's not the issue. It really and truly isn't. And what I think as a trial judge, one thing I've never done, and maybe someone can correct me if I'm wrong, I never make any decisions personal.
No.
It's not my job, it's not my role. And so I'm looking at this through this lens. His deposition was taken. There were documents out there. They weren't produced for his deposition. If he wanted to rely upon those documents as part of his testimony, it should have been produced before his deposition, right?
Absolutely.
I mean, and that's what the rules say. And just as important, I look at it through this lens, okay? If I'm gonna exclude documents, I have to conduct a Rule 37 analysis, right?
That's where I'm going. I got the rule right in front of me now.
You know, this is my first rodeo. I don't mind saying
So-
I gotta make a substantial justification and or harmless. How can I even make that determination?
Thank you, Your Honor. So, I want the record to be complete. Their third supplemental and fourth supplemental, the disclosures came after all of these depositions. The document that he's speaking of was produced in discovery on the fourth supplemental the day before the discovery ended, June 8, 2023.
I got
That's
a
number
question
one.
for you, but is that a meaningful disclosure?
Not even close.
Right?
Your Honor.
And there's a difference. Is that a meaningful disclosure of a document? Because if a witness is going to rely upon that document should be produced a reasonable time period before that deposition is
2
taken.
years before. On top of that, Your Honor, is referenced in the third supplement. The third supplement we actually attached to this opposition, Your Honor. If you could go to the third supplement, Your Honor. It's a 22-page document, the last exhibit in the,
I think I have that, yes.
if you go to page 17, I believe, Your Honor, of this document, it's item letter, W.
Okay, I see that, yeah.
It says here, complete email chain between Milwaukee Instruments and M. Bush, which is Mike Bush, of Rio Water, final date March 19, 2019. You see that?
That's it.
So, Your Honor, when we got this document, and you can see that it's dated, if you go back to the first page, it's dated June 8, 2023. That's the day before closed discovery, June 9th, 2023. Now, Milwaukee indicated that this document may have was produced in a different real water case, the Wren case, in May of 2023. But what they failed to mention, Your Honor, which we do mention in our opposition, if they produce it in May, great. But by that time, the initial expert reports were due in March. The rebuttal experts were due in April. All of the lay witness depositions have been taken. And the coup de grace, the special master report, which becomes an order of this court, required those productions to be done by December 29th, 2022, which would have been in advance of the depositions. And there's no dispute that they failed to comply with the special master order. And there's no dispute that they failed to comply with 16.1. And there's no dispute that they failed to comply with NRCP 34. Now, going to Rule 37, which is where the court is required to go based upon our Supreme Court decisions.
I know exactly where I have to go.
That's it.
I do.
And 37C is very clear. It says the party is not allowed to use that information or witness to supply evidence or emotion at a hearing or at trial if they fail to disclose as required by 16.1A1. Done. And they didn't do it. There is no recovery for Mr. Robbins' client or Mr. Rasmussen's client because Carl Savaggio is an employee, a managing speaking agent for both. And he was indicated, based upon sworn deposition testimony of Mr. Brown, to have been provided with all the emails and failed to produce them, Your Honor. So when you consider the Rule 37, Rule 16, Rule 34, the special master order, and the prejudice to all the parties, well, all the plaintiffs in this case, there's no way to not strike this and prevent and preclude the use of this document. Otherwise, Your Honor, I guess Mr. Brown was not being truthful and forthright when he said he gave all the emails to Mr. Carl Savaggio. Because you can't have it both ways. And then I guess Mr. Carl Savaggio would not be truthful because he failed to produce it. He signed the answers in interrogatories. Your Honor, the genuineness of this document is also an issue. Because certainly, if Mr. Brown told Mr. Kemp during his deposition that everything had been produced, and this document had not been produced, then perhaps the document was generated thereafter. The only other thing I would point out, Your Honor, when Mr. Kemp was deposing Mr. Brown, he looked on his computer during the deposition and he found another document that had been failed to be either withheld or not produced. And Mr. Kemp went through that document with Mr. Brown during the deposition. Mr. Brown did not find the document that they're speaking of right now during that deposition. Again, calling into question the trustworthiness of that document, John. And unless the court has any other questions.
So, I mean, ultimately, what are you asking for, Mr. Burke?
I'm asking that document be precluded from being introduced into evidence. And, Your Honor, I did not contest the health of Mr. Brown. I find it strange that he could go on with his life and be at work but can't come to court. I find it strange that this concern about wearing clothing, if he's at the office, I'm assuming he's wearing clothing, so he could wear it here. If this is a cost issue, you know, Mr. Robbins' client, I'm sure they have 121 locations between Mr. Robbins' client and Mr. Rasmussen's client, 61 offices in 47 countries. They can afford to have
That's a lot of offices.
From my review of the financial records, they're making roughly 100 to 140 million a year. They can afford to put him on a private plane, have him masked up and bring him here, and let the jury look at him, look at his mannerisms, test his credibility in full. So,
Well, but that's two issues. Number one, document. Number two, whether he can testify.
I'm more heavy on the document, John.
I understand.
Judge, I just wanted to add one thing on this document because I was in the middle of the discovery throw, and we filed a motion for default. and then we went to the Special Master Hale. He ordered them to produce everything, as Mr. Parker said. They didn't. We took his deposition, and we find out during the deposition that because when they produced, they didn't produce the body of that email from Mr.
So
Bush.
I understand, I remember
That
the
was
email
the
discussion.
key part of the whole email chain. Tell us how to oxidize this meat or calibrate the meat, I think. That was the key thing. So someone deep sixed that. I don't know if it was Mr. Savaggio, I don't know who it was, but they've never come up with the explanation for why they deep sixed that key thing. But anyway, these March 19, 2019 email, this was a red hot issue, okay? It wasn't just something in passing. So they were ordered to produce the entire body of the email, and they did. They produced that on March 1st, 2023. And when they produced it, this is how they described their production. Quote, complete email chain between Milwaukee Instruments and M. Bush of Real Water, final date March 19, 2019. Unquote. That was their language. They described it as the complete email chain. They put the date March 19, 2019, because like I said, that was the red hot date, okay? And that wasn't true. That statement wasn't true. So this wasn't something that was just casually referenced in a 16-1 production that was maybe handled by a paralegal and they didn't focus on. It should have been produced in 16-1. But this was something that after a motion for default was filed, after we had a discussion with the special master about why the body of this thing hadn't been produced, after it came up during his deposition of all places, then they represent on March 1st that they've made a complete production, okay? And now, 2.5 months later, I think they produced it first in the Wren case on March 19th. So, May 19th, I'm sorry. So 2.5 months after March 1st, even a little longer than that, they produced this. This is after the depositions are taken. We took Mr. Bush and Mr. Brown after the expert reports were filed. I mean, and now they come in, with this belatedly produced document, and the prejudice is unbelievable because Mr. Bush lives in Florida. Okay, he's already testified. We played it for the jury. Mr. Brown, all of a sudden we have not just one email that the body was withheld, and now we have another email that was withheld until the last minute with no explanation whatsoever. No statement that, the computers went down, no explanation. We asked them a specific interrogatory answer, which was who, just paraphrasing it, who deep sixed the body of the 3/19/2019 email, and their answer was blah, 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 blah. They had no answer to that. So even to this day, we don't know why the body of the email wasn't produced. To this day, we don't know why the 3/19 email that they finally produced on May 19, 2019 was produced. But to suggest that you can come to trial, and after we had the bench conference, you remember they wanted to refer to this email during opening statement? We had a bench conference about how they could not lay a foundation. And so that's the real reason they're trying to bring Mr. Brown here by video, to lay the foundation for that. A document that they didn't timely produce. But my biggest problem with this is that we have this red hot discovery dispute over March 19th emails. We have a pending motion for default. We have a special master order for production. They tell the special master even before March 1st that they produced everything. They make this representation on March 1st that they've given everything, specifically referencing the March 19, 2019 email chain. And then they come into the last minute and they want to add another email that was supposedly part of that chain. And I could go on, but that's what I really have a problem with. These representations about discovery that was produced that aren't accurate.
Sir.
Your Honor, everything they just argued, they argued before. Okay, and I do want to incorporate by reference because it's not their fault, the timing of this motion, that when the opposition was filed, was on OST. But I would like the court to incorporate by reference the entire hearing and all the arguments that you just heard, you heard before. And you recall asking me certain questions, you probably recall asking me what the prejudice was. And we had a discussion about manufactured prejudice. And we did talk about lesser alternatives and what they could have done and why a motion that was filed in January and supplemented every couple of months, it seems like, why did that take so long? And I think it was on both sides, they ended up continuing that, but if they were severely prejudiced, they could have brought that. There could have been alternative sanctions, and we discussed about this in the hearing, about we could have paid for a deposition.
But here's my question. That doesn't amount to waiver of the right to assert that there's lack of compliance with
Yeah,
Rule
can I address that now, Your Honor?
16.1, Rule 34, Rule 37, and so on and so on, because I'm looking here at the motion, and maybe it's my fault. I looked at it through this lens. I looked at it as a motion to strike the answer. That's a very high standard, right? As far as any other potential sanctions, I didn't address that issue. It just is important too. We have motions in limine, but if you don't file a motion in limine, that doesn't mean you waive your right to object to specific evidence, right? There's no waiver. And so here's my point. In light of the history of this case, where we had a deposition taken of a witness, of a key witness, managing speaking agent on behalf of a corporation, his deposition is taken. Before the deposition, they asked for all the emails, all the email chains.
They did not, Your Honor.
Well, we'll put
It's
it this way.
required under 16.1. They did not ask for those. They asked for communications between Hanna and Milwaukee.
Well, bottom line is, pursuant to 16.1, if you were going to rely upon this email, it should have been produced before the deposition, right?
Granted, Your Honor, it's more of a timing issue.
Well, timing's big.
No, I want to make a record because we did argue this, and I want to make a complete record again, Your Honor, if I may.
Mr. Robbins, you've been in this courtroom 100 times or plus
Sure, yeah.
or more. I've never prevented any lawyer from making a record. But my question is this: if it wasn't produced before the deposition, the witness wasn't given, the lawyers weren't given an opportunity to prepare meaningfully for that deposition because they didn't have the document in hand. And then the document is not produced until a day or two before the official close of discovery.
No, true.
How can that be utilized in trial? That's my question.
Okay. So we did a better job of arguing this in the hearing. So
No, my questions were related to
Yeah,
striking the answer. Now we're talking about excluding a document. That's a totally different standard.
Okay, and I'm, again, maybe I'm just not doing a good, effective job, Your Honor.
You always do a good job, Mr. Robbins.
But
I have some good questions.
we did
right
argue
now.
all these issues, we did. So
But I'm not
maybe the
going
court
to let
didn't
you.
think you.
And I don't want to cut you off, and I'll let you go ahead and continue. You always do a good job arguing. But sometimes you have good facts, sometimes you don't. And that's just part of what we do, and we do the best we can. Because at the end of the day, and this is how I'm looking at it, and this is why I'm framing it this way. Yes, I didn't strike the answer. Yes, I looked at the Johnny Riverio factors, and I made a determination that potentially it didn't rise to that level, because that's a really high level. And like you said, I agree with this. I believe cases should be adjudicated on the merits. But ultimately, that doesn't mean you get to use documents that weren't properly disclosed in your case in chief, especially when the deposition of a managing speaking agent and or key employee on behalf of the business has been taken and conducted, and the adverse party wasn't given those documents, wasn't given an opportunity to cross-examine him on those documents, and then lo and behold, a day before the close of discovery, those documents are produced. How can those be utilized?
It wasn't a day before, Your Honor, and even they admit that it wasn't a day before.
Okay, how many days?
It was May. It was like weeks, 3 weeks, a month, something like that. The point is, it was after the depositions. I'll give them that. But I just want to remind the court that the court set this on a expedited trial basis. And I don't remember the exact date of that, but when Mr. Kemp and I had the meeting confer on their discovery request, and it was it was a productive, I thought, meeting. Conferred. It didn't seem like it was gonna be that big of a deal. I didn't know at the time that Jason Brown was in the condition that he was in. I didn't know that, okay? And because of the trial setting issues, all the procedural dates, discovery dates, everything was advanced while he was in this condition. So his deposition was set, I believe, ultimately we had to keep fighting to have it moved and moved and moved. 2 days after he returned back to work, and I think it was on February 1st or end of January, something like that. So I did have a little bit of phone access to him in the week or two leading up to that deposition, very little. And our focus was, because at that point I wasn't able to get discovery, okay? I couldn't get the discovery. I tried, I couldn't get it. And we articulated all the reasons for that in the hearing. And ultimately, the discovery, the discovery that had been sent asked for communications between Milwaukee and Hanna, and it was largely seemed to be focused on establishing that the meters in question that Milwaukee sold to Real Water came from Hanna. So my focus when I finally had access to Mr. Brown was to respond to that discovery that I've been waiting to get access to him to respond, and I did. And not only did I, we responded 2 or 3 different supplements, and then they sent additional discovery, I don't know, just 3-4 days before his deposition. I turned that around before his deposition. And the documents that everybody keeps saying, oh, he didn't produce this complete email. The reason is, Your Honor, we discussed this in the hearing, I showed you the box, and even if you look at the exhibit of that document that we're talking about at 1153, it has a line across it, and this is the reason. And I'm just making a record for Your Honor. The communications between Hanna and Milwaukee and the invoicing is what happens, and you actually heard Jason Brown say it in his video deposition yesterday. When customers called in to order, he told them to send an email. So what they do, what you were looking at was not being produced as an email, it was being produced as an invoice. So what they do is when they get that email in from the customer, they rip off the page, if there's more than 1 page, and they take the one that has the order on it. And that's why you see the crease in that document at the top, because it's an actual paper file. And that paper file, that paper email that has the order on it, and it may have other information on it, but it was only kept in that manner because it was an invoice, not an email per se. And they staple that to an invoice from Hanna, and that goes in the paper folder, and I showed Your Honor the box that all that is kept in. So that's what it is. So then, during the deposition, I don't think anybody knew.
But don't they also keep the email chain?
They do, Your Honor.
In the order that they would be in?
They do, Your Honor, but you have to keep in mind, we were trying to get as much out as we could, okay? Much out as we could after Jason Brown came back, which was a 2-day period. And like I said, I want to be forthright with the court and opposing counsel. I had access to him for maybe a half hour, 40 minutes or something by phone a week or so before that, trying to see if I could find any more information.
I still don't have a legitimate reason why the emails weren't produced in a timely manner. I mean, I really don't. I mean, because it's an email chain, right? They produced some and they didn't produce others.
That's what I'm getting at, Gar. We didn't produce any of those emails until it came out after the deposition, okay? In the deposition is when the first time that email came out, and then let me get to whether it was a complete email chain. There are 2 email chains from Mr. Bush. Mr. Bush had, I don't want to call it he sent one email chain, and then what he would do is when he wanted to order something or do something else, he would send another. He would just click on an old email, and then so he didn't have to look it up or type it in, whatever the reason is. And Jason Brown responded to one of those, but it was 2 minutes later. 2 minutes later, Your Honor. And so when he said that complete email chain, the 1153 complete email chain was produced. We didn't see the other one until a month or so later or something like that. And we produced that. And it was produced before discovery cutoff. If they wanted to come to court, they could have we could have paid for those depositions to be had again.
Well, actually.
But this is a product of timing.
Well, actually, if you wanted to seek some sort of relief from this court, you could have sought relief during the discovery time period. You filed a motion and brought this and all in front of me, because at the end of the day, it's your client's failure to produce the email chain. That's ultimately what it comes down to. And I have to look at it from this perspective: is there any substantial justification, or whether it's harmless? And I can't say yes to either one, because, and I'm looking at it just two ways. I don't mind telling everyone this, because I'm always gonna tell you what I think of that. Number one, I think if I permitted the email chain to come in that wasn't produced prior to the deposition, that'd be reversible error. I don't mind saying that.
You just let one come in, Your Honor, the 1153 one.
Well, you
That was
know,
during the deposition.
It wasn't produced before.
yeah, well, it was produced.
Let's write the answer here.
Okay, it was produced as a result of inquiries during that deposition. It just happened that way. And you know what? That should have never happened that way, right? And I don't mind saying it. This isn't my first rodeo. I don't mind saying that. I mean, you know, I've been involved in, as a lawyer in complex civil litigation. I understand what the duties, roles, and responsibilities are when it comes to a party and production of documents. That's all I'm saying, and, you know, and it's pretty clear. And see, here's the thing, and I want to make sure the record's real clear. There's a big difference between reviewing a case and looking at case terminating sanctions pursuant to Johnny Rivero and all those cases versus excluding evidence that wasn't produced during the course and scope of discovery. And what I mean by that is this, and this is very important: meaningful, because just because it's produced a week or so before, if those depositions have been taken and the key witness who would be questioned on those documents, and you weren't given adverse counsel an opportunity to inquire, that's a problem. It really is. And so here's my, I'm going to tell everybody what I'm thinking. I'm thinking at this point, I still haven't made a decision as far as whether he can appear, but clearly he can't testify regarding the document. He can't testify regarding anything pertaining to that document, right? So what's left? That's what I'm asking, as far as his live testimony, what would be left?
Well, Your Honor, I would argue that they opened the door when they put up that screenshot and froze it on the screen, showing the different emails there from Mr. Bush on that day. I think they opened the door on that, so.
I think
I'm gonna
actually
make that
they just got
motion.
lucky, you know, and inquiring minds looked at it, and.
No, I mean in court, Your Honor, when they put it up in court.
I don't.
They identified those emails on those days. They're up there on the screen. They were up there on this screen in front of the jury for minutes.
They weren't given a chance to inquire into those documents and prepare for the deposition of, what's the key witness's name again, Mr.
Jason Brown.
Mr. Brown. They weren't, that's really what the issue is. Were they given an opportunity to have that document in their possession, at least a reasonable time period before the deposition was conducted? You know, I would think more than 48, 72 hours, right? So they can look at it and say, okay, maybe this will change the thrust, scope, and focus of my inquiry as it pertains to the depositions, right?
That's right.
I mean, isn't that how it normally is done? Because, I mean, I'm not saying lawyers can be perfect on everything, but if you find something late, maybe you could give the adverse side, look, 72 hours before, or 48 hours before, something like that, and the court can say, well, maybe, you know, that's a different issue.
So, Your Honor, I'll sit down now, but I want to, again, for the record, make sure that the arguments and the pleadings that were discussed ad nauseum in that prior hearing are made part of this argument and ruling, given the timing of the opposition being filed and everything.
And I'll say this, I mean, and I know what the Supreme Court does on those issues. I look at the whole record. I don't even think you have to make that reference, because I know what some of our Supreme Court justices do based upon personal experience. I know what they do. And some of them are very meticulous, because I won't mention names of some of the justices, but I've been in their chambers, and they have 3 or 4 computer screens lined up, and they're actually going through the transcripts point by point by point. And they do that. They do a real good job of it. And so when you go into a hearing, don't think they haven't looked at the transcripts, because they have. That I know.
But that, Your Honor,
So where do we
should
go
be
from
more-
here? Because I'm trying to figure out what's left if I exclude the document. What's the necessity for him to testify?
I don't think I have to disclose that in front of opposing counsel. That's part of my work product, Your Honor.
Okay, but what's next? I mean, what is he going to add other than what's contained in his deposition if I exclude the document? Because I'm going to exclude the document. That's not coming in.
Well, I can tell you this. If you're excluding the document, Your Honor, I would not risk this man's life to fly him out.
I'm not, no.
So I'm telling you that.
No, I said I'm excluding the document, right? I didn't say I'm forcing him to come out and testify. When I say what's next that he would testify?
I'm not going to disclose that number.
Okay, well,
So, and I don't think I'm required to.
but what would be relevant?
Well, there's other issues that he's discussed. He talked about hours to days for an org meter, his health condition at the time of that deposition. There's other issues he could talk about. That is not an exhaustive list, but I don't think I'm required to go through an exhaustive list in front of my opposing counsel. But if you want a sample, that would be a sample.
But actually, my question is slightly different than that, because I'm just trying to, I mean, I understand the rules, and I don't mind saying, I've had parties testify from Beijing, China.
He did correct it by 30
In
days.
China, in trial. So I'm just trying, my question is more of a general question. What else would be added to the case? Because I'm not going to let him testify as to the email chain. I'm sorry.
I understand.
Yeah.
So have you ruled on the others? Are you going to be able to be here via?
I just had one question. What else would be?
I just answered that.
Okay.
Well, no, may I address that last
No,
question?
I'm not through yet.
Oh,
So the argument from counsel is going to be, well, he could have corrected his deposition within 30 days. He said what he said. There's nothing to correct. It wasn't that the court reporter took it down wrong. That's what he said. So,
That's not the
if
basis
you
of
can
my
correct on the
decision.
stand, and it can be subject to impeachment. It's like,
No, the basis for my decision is really simply this. If that document was going to be something the defense.
we're past the document.
Yeah, but I'm just talking about the document. I want to make sure the record's clear.
No, I'm not talking about the document.
Yeah, if you're going to rely upon, your client's going to rely upon that in the defense of this case, it should have been produced.
No, that document has nothing to do with the couple of areas that I just gave you a sampling that we may want to still call him on. That's a game time decision probably. But there are other issues that are not related to that document. For that reason, hold on, Scott. For that reason, we ask you to at least grant the motion and give us the opportunity. I think there's extremely good cause. If this isn't good cause, I don't know what it is to have somebody testify by video. And that should be our option, whether we call them understanding the court's arguments, or court's ruling, I would say, or anticipated ruling on striking that document at issue. But we still should have the option, if we choose to have him appear and testify for this court, and for the reasons we've already briefed and articulated this morning, I think there is extremely good cause to allow him to do so if we choose to do that. And that's all I'm saying.
We may want to call him as well as part of our defense, and then they are two different entities. And so I don't want to be pursued for not being able to call someone that we think is important for our case. Thank you.
All right.
Your Honor, I only got up because looking at Rule 43 and then looking at the additional rules cited in our opposition, which are also cited in the brief. The court's inquiry of Ms. Robbins is well taken, because the rule asks for good cause and compelling reasons. So I think it's not just good cause in terms of.
And with the appropriate safeguards.
Exactly. So it's not just the good cause in terms of Mr. Jason Brown's health, there's also good cause in terms of his value as a witness to this case. And so I think the court's inquiry was one to Mr. Robbins to explain, without giving up perhaps work product, the areas in which this testimony is needed for their defense, which is similar to what you would do looking at their affirmative defenses in an answer to a complaint. It's similar to what you would look at, the court would look at in the pretrial memo. So I don't think the court was being too intrusive in asking that question. Mr. Robbins felt, didn't want to disclose what the real reasons are now that the document's been struck. But, Your Honor, certainly he should not be allowed to come in here, and I think it's a bad position to take, but for him to come in here and perhaps disavow the sworn testimony in his deposition, that would be appropriate. And if Mr. Robbins wants to set him up for us doing that, then I think that's even more important that this jury get to see him right here in this court. I would think that Mr. Robbins would have enjoyed the opportunity to explain the importance of having Mr. Brown come in as a witness. But he hasn't done so.
Well, here's what's, and I'm a firm believer. And for example, I haven't had a chance to do a deeper dive and see whether or not Rule 48A is identical to the federal rule under Morse, because I like doing that. I don't mind saying that. I enjoy doing that. You know, sometimes going back looking at some of the treatises. But here's my point. It doesn't just say good cause. It says, because it's really clear. It says, quote, this is 43A in open court. At trial, a witness's testimony must be taken in open court. That's mandatory, right? That's like, there's an exception. But let's look at the language of the exception. Because we'll go through it again. At trial, the witness's testimony must be taken in open court unless provided otherwise by applicable law, period. Now, here's where the rubber meets the road. It says, quote, for good cause in compelling circumstances and with the appropriate safeguards. Okay, that's pretty strong language for good cause and compelling circumstances. It doesn't just say good cause. It says good cause and compelling circumstances. What does that mean?
Your Honor, and this is what I'm concerned about. Mr. Kemp and I, in discussing this motion yesterday.
Because I don't mind saying this historically. I realize I don't always get it right in the judge trials. But no matter what, I've always been tethered to the rules. Right? I just don't do things sua sponte. I never do sua sponte. No. I don't. And it's always tethered to the rules.
What I'm concerned about, Your Honor, Mr. Salvaggio has not made an appearance in this court.
And I'm gonna make this, I'm gonna step down for a second.
No worry, John.
I'll find it.
I'll stand.
But I'll show
All right. Be seated. Okay.
When you say Blaine Jones damages, what do you mean by that?
We already did it.
I know, but what does that mean? I'm
When
lost.
he got
what
sick,
that reference.
he got sick on the elk hunting trip.
Oh, just that part of it?
Yes, that's all they showed.
You already did. Did he have to switch one?
All right.
May I continue, Your Honor?
Yes, you may.
So, Your Honor, the other concern I have in terms of the safeguard issue, how do we know that Mr. Brown will not be assisted in some way when he's not in this court and he's in North Carolina? I have no idea whether or not Mr. Savage will be there with him, someone else will be there with him, helping him through this process. And that's why the court in-person testimony is so valuable to not only the court, but to the finders of fact. And so I think that's why the Rule 43 requires compelling circumstances. Now again, we don't dispute his illness, but I think proper safeguards can be made for him to testify here. Properly masked, properly transported. We don't know what day they intend to bring him. Mr. Robbins' case is the last one. So we have no idea what his condition will be in 4 days from now, or a week from now. But what we do know is that for whatever reason, this motion was not brought before trial started. And I think it's a convenient motion made and a decision made based upon the bench discussions. And it's more strategical than anything else. And I don't think that satisfies the.
And when you talk about the time period, where does that come from, Mr. Parker?
Oh, if you go to the Supreme Court rule, Your Honor.
I understand.
Page 250, page 251. Article 9, 254, as a matter of fact. And it says, I believe it says it has to be done within 5 days, Your Honor.
Identical what?
I think Mr. Robbins is correct. I'm struggling finding it right now, but it is 5 days, I believe, prior to.
Appearance.
And you know, what I find fascinating, I had a fairly specific question regarding, okay, what's going to be different, or what's overlooked as far as the deposition test was. And I know Mr. Robinson objected, but I'm looking here at Moore's Federal Practice and Procedure, section 43.02, bracket 2. It says, quote, Rule 43A, strong preference for the use of live testimony in open court is not absolute. However, in addition to the exceptions provided by the federal rules of civil procedure and evidence, by statute and by the Supreme Court rule for use at trial as such discovery devices as depositions and interrogatories, some courts have required submission of written summaries of direct testimony. And here's my point. All I'm asking, this is a general question, what would be different than what's in the current depositions taken? But I guess some courts, like me, have a somewhat of an inquiring mind, wanting to know, okay, what's different? I mean, because I'm trying to figure out what would be the necessity, because it's right here, it says, quote, some courts have required submission of written summaries of direct testimony of each party's witness in their case in chief, period, close quote, right? And they do this on the federal court level. I just have a simple question as to, okay, and I guess I'm really trying to focus on what would be the harm to the defendant if they're precluded from testifying live.
Right.
That's all. I'm just, you know, what are we missing there?
And the answer to the question in terms of where that 5 days comes from, Your Honor, is actually Rule 4 of this, it's page 256 of the Federal Rules of Civil Procedure. Of our rules, and it's subpart 2, 5A2. It says 5 days before the appearance, notify the court and all other parties of the parties intend to appear by simultaneous audio-visual transmission equipment. If the notice is oral, it must be given in person. If the notice is in writing, it must be given by filing a notice of intent to appear by simultaneous audio-visual transmission equipment with the court at least 5 court days before the appearance, and by serving a notice at the same time on all other parties. So that's the timing component of your argument.
Which rule is that, Mr. Park?
Yes, Your Honor. It's under Rule 4, under Article 9B. If you're looking at the rule book, it's page 256.
Okay.
The only other concern I have, Your Honor, under Article 9B,
And you say 256 in the rule book?
yes, Your Honor, if you look at 256, notice by party, see paragraph 5A, then you go to the next, up to page 257.
I don't know if we have that. I'm looking at 256, and it's guidelines for interpreting the federal rules of professional conduct.
I'm looking at Article 9-B, rules governing appearance by simultaneous audio-visual transmission equipment for civil and family court proceedings.
And that's under Supreme Court rules, Mr. Park.
Yeah, if I can approach one, I can show it to you in my book.
Oh, no, we'll find it. What is for, paragraph 1, 2, 3?
If you look at paragraph 5, it says notice by party,
Okay.
then A1, and then A2. A2 starts the notice requirement.
Can you approach Mr. Parker? Sir, you see anything on the book? We have the same book.
I may have my, oh, I have my 22 in front of me, I didn't bring my 23, it's the same, I looked it up. But the date, pages may be different, pagination may be different. This is, this is where it's from.
Well, they completely changed it. Or 9B?
Yes, sir, for sure.
Oh, yeah. All right, and that's Roman numeral 9B, is that correct?
That's correct, it is Roman numeral 9. It is in Bravo.
Yeah, they made changes. But go ahead, sir.
And Your Honor, it speaks about the 5-day requirement, and that's what I was referring to, Your Honor. Again, I think this was a knee-jerk reaction to the bench discussion, during which it became clear that this document had no foundation, had been produced after all the lay witness depositions and after all the expert depositions.
And what rule is that a Supreme Court rule? Where's that found at? What section?
It's a part of the Supreme Court rules, Your Honor. It's the, if you're looking at your index, which I assume the index is fairly similar, it's under the Part 9. If you go to the index, it's Part 9, Roman numeral 9, that is, rules governing interference by audiovisual transmission. You look at the index.
I got it.
You got it?
I think so. Which one are we looking at as far as the rules? Because I'm
Part
looking
9.
here, and this is what I have, and this is why it's good to check. And is this incorrect? But I have rules governing appearances by audiovisual transmission equipment repealed. That's why I always think it's important. It says repealed. I don't know. Here, take a look, sir. Because I want to make sure whatever decision I make is guided by the correct rules. You can show it to Mr. Rasmussen.
That's why I'm bringing it to both Mr. Rasmussen and Mr. Robbins, because
Yes.
this is what was cited in the motion.
Make a decision based on something's been repealed.
But that'll be good.
I'll never do the obvious. That I promise you.
That would be easy.
Never do the obvious. Now the nuance, you know, sometimes it depends just from a philosophical and or policy perspective why decisions are made. I get that. You can be on the wrong side of that easy, right? But I'm not gonna miss the obvious.
Well, we know about the Orion was 2018.
A lot of fun.
Maybe that they put
It still says 5 judicial days, Your Honor.
That part was repealed, and then it comes into 9AB or BB.
Okay.
So that is still the same.
If both of you can tab that so I can take a look at it later, make sure Mr. Robbins can see it, because I want to spend time with the rules, so I'll decide what I'll do with the,
And there was a time I know, in this, probably in this court, but certainly in other ones that I was trying during COVID, that they had all sorts of, we had a lot of witnesses that were done via transmission.
Oh, yeah.
Because of that. And I'm not saying that's effective in this trial. I'm not saying that. I'm just saying that some of this may be as a result.
and I want to make sure, now I'm looking at Rule 4, and which section do I need to look at so I can review?
May I approach?
Yes, sir. So I can
It's
tab.
cited in our brief, but just having glancing at your. But if you said something,
And Mr. Robbins, thank you for that. We don't consider that. I'm gonna put that be, get my tab out.
may I just finish this up, Your Honor?
Oh, absolutely. I want to make sure. Get my- No, I understand. I want to make sure I can find it. So it's Rule 4, subparagraph 3 is where it's at in the new book.
I think it's just when the times changed and the court favored, letting people testify.
Oh, yeah, I do.
It's down to the court.
Yes, sir.
You're ready for me to?
Oh, yeah.
Okay. So just briefly, I'd ask you to look at La Barbera. The parties in that case are arguing about Rule 43 and compelling circumstances. I think we've more than articulated that to meet that rule. But basically, the court is saying, why are you guys looking at that? Look at our Supreme Court rule. Okay? And it favors letting people testify, notwithstanding the compelling circumstances. And in that case, La Barbera, it was a guy who we had a warrant out for here in Las Vegas. And his big thing is he's from Italy. It was cost. It didn't have anything to do with even his life. Maybe it had something to do with his freedom, but and the court said the court abused discretion and not allowing him to testify by video. Right? That's it. Unless you have any questions for me.
Your Honor, one point to Mr. Robbins.
One
One point to Mr. Robbins I think got wrong in the case. The Supreme Court reversed the district court on that because the court didn't give an explanation why it denied it. It summarily denied it without giving any explanation. That's why it was reversed.
Now, here's my-
and his freedom was the issue.
And here's my question, and I'm looking at the Rule 4, and it appears to me, maybe I'm missing something, but the thrust of it is focusing on criminal cases and the right to confront, right? That's part of it. And so I'm looking down here, personal appearances by simultaneous audio video transmission equipment. That's one of the, get that. And here's my point, I look at 4.3, which is really kind of odd, because normally they'll have it different than that, it'd be like 4.8 or whatever. But the bottom line is, it says a party wishing to offer appearance of a witness at a criminal proceeding by simultaneous audio-visual transmission equipment under this rule shall not be later than 5 days before the proceeding. Okay, I get that. So does the 5-day period apply to civil cases?
It had it on both, Your Honor. I think we agreed to that.
Okay.
They have it on the criminal, they have it on the civil, and the family court. It all says 5 days. That was my reading.
And
Okay, so here's my next question then. It says good cause, if it's not done within 5 days.
Good cause and compelling, I think compelling circumstances, a good cause under the, compelling under 43.
Oh, you said it's a 5
It's
days?
filed on Monday, last Monday on the 18th. He wouldn't be appearing until sometime middle of next week. So it's really, I don't think it's an actual issue, other than the rule being what the rule is.
Well, it says not later than 5 judicial days before that proceeding. How do I define that? Is that starting from?
The case law though says about when the witness appears.
No, I'm just looking at the rule.
All right, Your Honor, may I approach him?
Yeah. Make sure you have it. As soon as I can. Thanks. I just want to make sure I get the right section. There's so many rules.
There are.
I'm just going to refer the court to, this is Part 9B as well, just for the sake of, if we cited Rule 2, which is here on this page, so it wasn't the repealed section, it was here. And here it says, notice by party at least 5 court days before the appearance.
Okay. Tap that.
I think this is, I don't know if this is civil. That's what it's actually-
I think the other-
Here it is, equipment for civil and family court proceedings. So I think that's probably the one.
The criminal, I think. make a decision on that, on the appearance today.
Thank you. Thank you, Your Honor.
So is there anything else?
Nothing to play with.
Another 5-minute break, maybe would be good.
Let's take a break, run to the men's room, and then we bring the jury in. Continue on. And tell me, is the one panel member back, Mr. Marshall?
Yes, the panel member who had an appointment this morning is back. I am waiting on one more juror to arrive and we'll have to.
Okay, let's take a